Hi, this is Stuart Weinstein from Legal Talk, and thank you for being with us here today. Well, every profession has them, and those are the regulators. The good, bad, and ugly, and in Canada, in Ontario, in the US. Today's episode, and this is a blueprint episode for other regulators, is the Law Society of Upper Canada. When you think of the Law Society of Upper Canada, do you think of this? Or do you think of this?
Of the Holy Cross of our Lord Jesus Christ, who lives and reigns with the Father and the Holy Spirit. Damien!
That's what we're going to be discussing today when we talk about the Law Society of Upper Canada. Today we have three distinguished, prestigious guests at the top of their field, all three lawyers. We have on my left, David A. Seed. We have Bill Gilmour, and to my right is Neil Perrier. Welcome to the show, gentlemen. David, can we start with you, a bit about yourself and your perspectives of good, bad, or ugly with the Law Society, where you rank them?
I've been practicing for about 18 or 19 years. I have, in more recent years, found myself dealing with discipline matters with the Law Society on behalf of members. I would say my views of the Law Society are that once they're on your case, it's a heavy burden to bear, and it is something that is practiced and soul destroying for lawyers. And I think lawyers make the mistake when they're involved with a Law Society of believing they can represent themselves because they know something about law and because they have legal training. And the fundamental problem that they have when they appear before them is a complete mismatch when they find themselves before a discipline matter.
And Bill Gilmour?
I too practice law. I've been practicing for 25 years. I practice in Alberta, Ontario, and England and Wales. And as David, I've found myself appearing before the Law Society on a number of discipline matters over the past few years. I echo David's comments of the fear that lawyers feel whenever they've been called before the Law Society to answer to any conduct. And I echo his position also that nobody should be there unrepresented or represented by themselves.
And Neil Perrier, your thoughts, please, and about yourself.
I'm a lawyer. I've been a lawyer for approximately 22 years. The main focus of my practice is professional regulation. I've acted on behalf of regulators and defended professionals, including lawyers, doctors, engineers, other healthcare professionals. The Law Society is there to act in the public interest. I agree with both the gentlemen who spoke before me that when they undertake a prosecution, they do so with vigor. You should never be self-represented before the Law Society. The discipline counsel are very good at their jobs. They know what they're doing, and it's a very difficult process to find your own way out of.
In terms of that. In terms of, now starting with you, let's talk about transparency. Do you feel that regulators, like the Law Society of Canada, Upper Canada, is transparent? Do people know what's happening inside in terms of the fact that they're not on the sunshine list and we don't know the amounts that they're making? Or is there any other things that need to be more transparent?
Well, you have to be careful with that because their investigations cannot be transparent. Lawyers who are under investigation, it shouldn't be known to the public that they're under investigation until charges are laid. Their discipline process, once charges are laid by way of a notice of application, it is a transparent process. The hearings are held in public for the most part, unless there's reason to do otherwise. And they are reported. Once charges are laid, they have a Stinchcombe-like disclosure obligation, and they, for the most part, fulfill that. So the process itself, the discipline process, is transparent.
Mr. Gilmour, your thoughts about transparency at the Law Society of Up Canada?
I would agree that by and large the discipline process is transparent. When Mr. Perrier talks about the Stinchcombe-like requirement for disclosure, it is somewhat modified at the Law Society because of client confidentiality, and the Law Society seems to have a strong preoccupation with not giving any information out of other members and other lawyers' files to lawyers who are facing discipline charges. And to that extent, sometimes it's difficult to make a full and proper answer in defense because defense counsel doesn't get all of the information that's required to fully inform the defense. And again, that's a debatable question because a great deal of it falls under the very legitimate concern that information that shouldn't be given to other people isn't given to lawyers just because they're defending another lawyer.
David? Oh, Mr.
The law, however, is that they need to disclose all relevant information which is relevant to the charges laid in the defense of the lawyer. If you dig, you will get it from the Law Society, and if you don't, you can bring a motion, and you're certainly entitled to it at law, in my view.
David?
In my experience, counsel for the Society is more generous with their disclosure obligations than most opposing counsel, Crown counsel, other lawyers and other proceedings. They almost go overboard. But I think that's the nature of the discipline counsel. The decisions, the internal decisions, and the instructions given to those counsel, the discipline counsel, I don't always find quite as clear as the disclosure of counsel themselves. I think the decisions which lawyers are going to aim their sights at, why they do it, what other motivations the society may have to go after certain members, I don't think is always clear. It's not always apparent to me representing lawyers why they're so high on the list and why others have been passed over.
And now in talking about the customer service, so Bill, we'll start with you. In terms of the concept of the customer service when you've dealt with the Law Society, how would you rate that? Good, bad, ugly?
I'd rate it as good. I think they're cooperative, they're forthcoming, and they're responsive to questions and concerns that are asked. You might not always like the response, but I think they're always forthcoming.
And David?
I don't have any complaints about their customer service. I've been involved as well with them with their on the education side and assisting them on the licensing. And I find them, if not congenial, outrightly pleasant, more than congenial, I guess. And a very comfortable place if they want you to come in and assist, putting together something for them for internal use. Excellent people to deal with.
And Neil?
I agree. The administrative branch is different from the disciplinary branch, but for customer service, as far as knowing what fees you have to pay, what documents you have to file, they're a very efficiently run organization, and I think they serve the profession well.
And in terms of the government, do you think the government's afraid of them, or the government regulates them as much as they need to with other regulators? Like if you were the government, if you're the Attorney General, and you had the chance to make changes to the Law Society, Neil, David, start with you. What do you think you would change?
If I were the Attorney General?
Yes, and you had carte blanche to go in there and make some of the changes that need to be changed. What would you change?
I'd like to hear Neil's first.
Okay.
Yeah, obviously, we're talking about doing amendments to the Law Society Act. The provision of the Law Society Act, or provisions of the Law Society Act, that I find most tilt the scales on disciplinary hearings are the cost provision. Under the Law Society Act, the Law Society is entitled to costs if it's successful in a prosecution of a lawyer, and they regularly seek those costs. If a lawyer is successful in defending himself or herself, they're, for the most part, not entitled to costs from the Law Society. The test for costs is very high. The reason for that, or the reason that's been articulated, is it's a civil proceeding and not a criminal proceeding, and so costs, the Law Society should be entitled to obtain costs. If that's the case, then in my view, lawyers should also be entitled to obtain costs if they are successful in the defense of their action, because they need to be involved in that action. Their careers are at stake. And quite frankly, the stakes are a lot higher in certain circumstances than those of a career criminal who may otherwise be residing mostly in prison. lawyers' livelihoods are at stake and livelihoods of others are. If I could think of a provision that needed amending, it's that, but I don't hold up much hope that it ever will be amended. Similar provisions are in respect of other regulatory bodies, College of Physicians and Surgeons under the Regulated Health Professions Act, professional engineers. But it makes the playing field rather unfair, in my view.
Mr. Gilmour?
I would echo that. That's the top on the shopping list of things that should be changed, and that is the availability of cost to somebody who successfully defends an action in a disciplinary proceeding. The Law Society very aggressively defends the turf that these are civil proceedings and civil in nature. The criminal rules don't apply, and there's all kinds of reasons why they prefer to have it staked out that way. But it's quite an unfair playing field, in my view, that you stake this out as a civil proceeding and then you don't make the availability of costs bilateral. Another issue that occurs to me is could use some work, and I'm not sure how it could best be approached, but hearings are held by benchers, and benchers do a great job at hearings. However, they're hard to assemble, they're hard to find. They all have other lives, other careers, other things going on, and that delays the time in delivering of decisions. And it occurs to me that there's a particular skill set that's not common to everybody in hearing evidence and making decisions. It's quite different than marshalling cases. And an assembled group of, shall we say, designated and professional compensated decision makers, as opposed to choosing from a pool of benchers that happen to be available, might be a very good thing to institute.
And Mr. Seed?
Well, to follow up on the points of the last two guests, a person who finds himself, herself being prosecuted by the society finds themselves in answering a case that the society may have spent 3 or 4 or 5 years putting together or assembling. They may have had forensic accountants, they may have had expert witnesses who delivered fulsome reports. And once the matter is on, the society advances them very quickly to a hearing stage, and it is financially onerous to respond to a case. The disclosure that comes in a case, so the Law Society might come in 3 or 4 bankers' boxes that the Law Society has had years to put together. And it is an expensive undertaking to defend. In cases of mortgage fraud, for example, the society may choose to advance their case, sometimes without direct evidence, but by making indirect inferences. So these cases are complicated, and the defense is complicated. And I agree with counsel that it can be a practice-destroying exercise to defend against, with no upside if you're successful.
Would you consider the Law Society of Upper Canada sort of the regulator of regulators? Because, for example, in Ontario, there's 40 regulators. So if you're brought upon any of the other, you don't hire a dietitian if you're an architect and you're being prosecuted. You hire a lawyer. So would you consider sort of the Law Society above the law, the regulator of regulators, untouchable, or are they doing their job that the public needs?
Well, I think the Law Society is a general principle is doing the job that the public needs, because it's a self-regulatory profession. If we didn't have self-regulation, we'd be regulated by the government, and I would predict that that wouldn't be a better predicament for lawyers to be in. Having said that, I think the Law Society does as good a job as any other of the major regulators in Ontario. The only real difference is when you're before other regulatory bodies, such as the College of Physicians and Surgeons of Ontario, the committee itself has independent legal counsel to guide it on legal arguments. At the Law Society, that's deemed unnecessary because it's lawyers, for the most part, and public members who sit on the panels. I think with respect to what the Law Society has traditionally regulated, it does an excellent job on the matters it's traditionally regulated. It's now more and more seeking to regulate civility and conduct, and I'm not so sure where that's going to go, but that will be interesting to watch over the next couple of years.
Mr. Seed?
My sense of how the Law Society governs compared to others is I do think they are susceptible to outside influences. I give again the example of mortgage cases. My suspicion is that there's been high-level discussions between banks or perhaps government and senior people of the Law Society about whether or not mortgage work might be taken away from lawyers if they don't do a better job of going after lawyers. To that extent, where they suspect there's mortgage fraud, they are exceedingly vigilant and exceedingly aggressive in their prosecutions. And compared to other professions, in that regard, I think more aggressive. There's many other quacks and people practicing in certain regulated health professions that seem to skate away from many of the problems that they create better than lawyers do when they find themselves within the subject of a complaint.
And Mr. Gilmour?
I've heard the allegations and the stories about the motivation for pursuing mortgage fraud as vigorously as it is. There's certainly a public interest in pursuing mortgage fraud, but I would have to say that, and I can't base this on any empirical evidence, but I'd have to say that my feeling is that there is something going on there to motivate this beyond absolutely rational means, and I'm not sure what the relationship is between lenders and banks and mortgage professionals such as brokers and real estate brokers, but there's certainly in my view a much enhanced aggressiveness towards mortgage issues that goes beyond rational analysis that you would find, for instance, in a criminal court or in a civil court.
The only rational analysis that I could offer up is it's not unlike misappropriations. Clients have to fundamentally trust lawyers to be forthright with them regarding mortgage transactions and any fees that may come in and out of their trust accounts. And without that fundamental trust, the profession itself would be in trouble. So in that sense, I don't know if there's been any outside pressure or not, but in that sense I can understand why the Law Society would move very vigorously on mortgage fraud issues, just as it does on misappropriation and misapplication of trust funds.
Now, this is a blueprint episode in respect to future things that we're going to be doing for the Law Society in terms of investigations and other regulators. As a wrap-up, what is your feeling as to where the Law Society is going to be going in, say, 2012? Will the government come in and take over? Will it continue to operate as it is? Will it get stronger? So where do you see the Law Society going in 2012? Or will there maybe not be a Law Society and come January 1st, 2013, the Law Society of Upper Canada no longer exists?
There'll be a Law Society for the next 100 years and farther into the future. Law Society is over 100 years old. There's always been self-regulation. I don't think the government has any interest in wanting to regulate the legal profession. It's effectively regulated by its regulatory body, in other words, by itself. Nor do I think the government should regulate the legal profession. I think that would be a dangerous precedent to the independence of the bar.
Mr. Gilmour?
I agree. The Law Society will be there for hundreds of years to come. It has to be, and the last thing that we ever want to see is the government regulating lawyers, for indeed lawyers are the only defense between the public and the power of the state. That barrier has to be there at all times. I think over the next year, the Law Society will continue much as it has. There may be some minor tinkering and there may be some improvements, but it's going to go much as it has.
And Mr. C.
Yeah, I would echo what the other speakers have said and add to it, being a bencher is a prestigious position within the profession, and becoming a bencher is part of the career trajectory of a lot of people who have higher ambitions, and taking away the Law Society and that administrative involvement of the profession would be very vigorously fought by members of the profession, if only people who have those sort of political ambitions.
Well, this is Stuart Weinstein from Legal Talk. We've had three distinguished guests today, David Seed, Bill Gilmour, and Neil Perrier, who are very familiar with the Law Society. This is a blueprint episode, so we're going to be doing more information on regulators in Canada and Ontario in the States, how they operate, where they need to go from here. You'll be able to reach any of these gentlemen through Legal Talk, 416-224-0200, as well as their individual information, legalall.info, as well as on Twitter, @legal. I'm Stuart Weinstein. In terms of building on viewership, investors, sponsors, and advertisers, we look forward to bringing you other innovative and topics of discussion that no one else talks about. Coming up next, we're going to be talking with Noel Biederman, who is the president of Ashley Madison, and we'll be discussing how he's creating jobs in a new industry, and when you have an unemployment epidemic, where things are going from here. I'm Stuart Weinstein, and this is Legal Talk.